Good afternoon, Judge Lekar, or good morning, I guess. It's still morning. You've been here all
Good
morning.
morning, Justice Wiggins. And it is still morning, yes.
Thank you for coming, and we'll hear your opening remarks when you're ready.
Thank you. I am pleased to be here today to have the opportunity to talk to you about my application for the Court of Appeals. Over the course of the past year, I think I've had the chance to visit with almost all of you, and I know that you're all fairly familiar with my background details, so I'm going to keep that portion of my presentation here this morning fairly brief. I did graduate from Iowa State University with a Bachelor of Science degree in psychology with honors and distinction, and from the University of Iowa College of Law with distinction in 1993. I engaged in the private practice of law in Black Hawk County and in greater Northeast Iowa from 1993 until 2005. In 2005, I was named as the first female district court judge in Judicial Election District 1B. In 2012, I was named as the chief judge of the first judicial district. I was born and raised in Black Hawk County. My husband is an architect and a partner in a firm in Waterloo. We have 3 kids, all teenagers, 2 in high school, 1 in college at Iowa State. Today I want to talk to you about how I believe my personal qualifications line up with the Court of Appeals, and particularly with regard to 3 aspects of the Court of Appeals that I think everyone should be talking about. And those are the volume of the work that the court does, the nature of the work that the court does, and the impact of the work that the court does. With regard to the volume of the work that the court does, I think the stats are important. In 2017, the Court of Appeals decided approximately 1,290 cases. In 2018, approximately 1,160 cases. Over the course of the past several years, the Court of Appeals, on average, decides approximately 1,200 cases. I think those statistics naturally lead to the question, how does a 9-member court, working in shifting panels of 3, accomplish that volume of work in a given year? I've taken the time to speak with former members of the court, present members of the court, and I think the answer to that question is twofold. First, obviously, hard work. But second, a mutual, collegial focus on execution, meaning that they do their hard work together as a team. I think that I am prepared for the volume of work that the court does, and also to join that court as a member of the team. As a district court judge, I carry a full docket of cases, and in addition, I also do the considerable tasks that go along with being chief judge. The work and the volume of work that I do now prepares me for the volume of work that would be required by the Court of Appeals. As a chief judge, I have also honed my skills in working in collaborative working environments with other judges, listening to their differing perspectives, providing leadership, and building consensus with those judges. Also, over the course of my time with the judicial branch, I've built collegial relationships with the present members of the Court of Appeals, which would add value to my ability to join that court. Part and parcel with the volume of the work that the court does comes the nature of the work that the court does. The Court of Appeals is the appellate court in the state that touches the widest array of cases and directly impacts the largest number of appellate litigants on a yearly basis. The Court of Appeals covers the whole spectrum of legal cases: civil, criminal, family, juvenile, and post-conviction relief. I believe that I have the depth of experience to be able to immediately join the Court of Appeals and deal with these nature of cases. In the 12 years that I was in private practice, I had a broad and diverse civil practice in which I engaged in both plaintiff side and defense side personal injury work. I did real estate, I did some workers' compensation, I did probate, I worked in juvenile court, I also did a great deal of municipal law, and for many years I accepted court appointment doing appeals handling juvenile court cases. As a district court judge, having general jurisdiction, I hear all manner of civil cases and all manner of criminal cases in any given year. Important in particular to a position on the Court of Appeals is the fact that for 2 years I served as a full-time juvenile court judge, And for the past 11 years, I've served as a backup juvenile court judge. So I've talked to you about the volume of work that the court does. I've talked to you about the nature of the work that the court does. I also think that understanding the impact of the work of the Court of Appeals is an important aspect of my qualifications. The process you're going through here today will replace 2 Court of Appeals judges, both of whom had trial court backgrounds. Having a trial court skill set is important and lends itself to understanding how appellate decisions are implemented at the trial court level. My experience as a trial court judge gives me insight on how appellate decisions impact judges, attorneys, and litigants. I believe that appellate decisions need to be easy to understand and clear in terms of implementation. And my role as a chief judge gives me an even broader perspective concerning the impact of appellate cases, because not only as a district court judge do I have to understand how a particular case may apply concerning a particular case that I might be hearing, but as a chief judge, I have to be sensitive to the fact that there are appellate decisions that have a broader impact and may change how an entire judicial district does business concerning a particular issue. My concluding thoughts in my presentation concern the Court of Appeals and how my personal qualifications interplay with the court. As I mentioned, you're replacing 2 judges, and I think it's no secret, or at least it's fairly well known, that there will be some additional vacancies on the court within the next year. That means that the appointees need to be able to hit the ground running, adapt and take up the work of the court immediately, and be able to be a team member and also assist as a leader in transition for the Court of Appeals into the future. I do believe that I am the candidate that can do that. I have a depth of experience in practice and as a trial court judge. I've built collegial relationships with members of the Court of Appeals. I've worked in collaborative environments with judges and leading judges. I've developed my leadership skills and my outreach skills, which are important at all levels of the court. I believe that I can seamlessly transition onto the Court of Appeals, and that an appointment to the Court of Appeals would be a natural progression of my experience and my dedication to service with the judicial branch. Thank you for your time. I'd be happy to take questions.
Thank you, Judge Lekar. We'll start questions with Ms. Pearson.
Thank you for being here. Thank you for being here, and thank you so much for your application. I've had a number of times to meet with you and to speak with you, and certainly enjoyed our conversations and learned a lot, as I have from all of the applicants. But one of the things that we talked about was just the transitioning to working in the panels and so forth, and kind of the, how should I say, you work as a team, but everybody's got to kind of do their part. And one of the comments you made, I mean, in a complimentary way, in the sense that you got to kind of trust all your team members that we're all, getting our work done and doing it timely and doing it concisely. Would you care to, expand upon that, please?
Sure. In one of the conversations that I had with one of the present court members, she emphasized the fact that trust is part of their collegial team atmosphere. And that trust is a trust in the other judges on the Court of Appeals, that they're doing the work that they're supposed to be doing as well, because of the volume of work that the court does. And that trust is both sort of a small trust and a large trust. And that small trust is that on the small issues that you might disagree on, that you have the trust in your colleague. If, say, for instance, that's the colleague that's writing the decision, you have the trust in that person to sort of let the small things, to trust in that person to resolve those small things. But the professional trust also works on the large issues, meaning that if you have a difference of opinion on a larger issue with one of your colleagues, that you have the professional trust between you, that you can debate that issue in a healthy, collegial, professional atmosphere and resolve that and still keep the train of cases moving and the volume and the flow moving through the court.
Thank you.
Thank you.
Ms. Bowden?
Thank you, Judge Lekar. I see that you practice as a judge in 11 counties, 9 rural, 2 urban.
Correct.
I have heard that justice is different in rural versus urban counties. I'm not saying good or bad, but have you noticed that difference, and if so, what is it?
Absolutely. Justice is justice everywhere. We try to, as judges, make decisions the same, no matter what county we're sitting in. But how justice proceeds and how cases move, and even how lawyers conduct themselves differs from county to county. I talked about this actually when I appeared before you one other time, and I don't want to be super redundant on that issue, but absolutely, small county court days where all the attorneys in the county gather, everyone gathers around the law table, you have those developed relationships, they know that they only have a judge for that one day sometimes of the week, and not only are they concentrated on getting their work done, but they're also concentrated on maintaining those professional and collegial relationships that they have, is a different atmosphere than the type of situation that you might see in a larger urban atmosphere where you have attorneys who rush in, do the hearing they need to do, and you don't maybe have that gathering spot or that continued development of professional relationships. So there's that difference. But in terms of service as a judge and how we approach that, I think when I'm in the rural counties, I want to make sure that those attorneys, those litigants who may only get a judge for a day, feels like they've really gotten the service out of that judge for that day, and that person has been there, has focused, and has done the work, and fully participated.
Thank you.
Thank you.
Mr. Berger?
No questions.
Mr. Diaz?
No questions.
Ms. Law?
What percentage of your rulings are not issued within 60 days, if you know that?
Very few. I don't even know. I've never, I've filed my 2210 reports late, but not necessarily because I had a late decision, just because I missed the deadline. We have like a 10-day window in which we can file those 2210 reports. But have I, over the course of my 13 years, had a case that went beyond the 60 days? Yes, but it's less than 1%, if I had to put a number on it.
Thank you.
Thank you.
Mr. Bevel?
Judge Lekar, practicing in rural and urban counties, do you see a difference in sentencing recommendations in those counties? And as a judge, what do you do?
I do see a difference. And as a judge, I try to be as consistent and impartial and as law-driven as I can be across all of the counties that I sit in. The primary difference, and this is not to disparage attorneys working in criminal court in urban counties. It's not to say that they don't have good working relationships. But those in rural counties, again, these are the same people who are working with each other very consistently. They tend to know each other. They tend to know sometimes the defendant or the families of the defendant that are working through their criminal justice system. And so how they work together, how they may strategize to plea bargain, how a county attorney may strategize to charge a case when they do charge the case does differ from county to county. But when it comes to sentencing, when it finally reaches resolution before a judge, that judge needs to continue to be as consistent, as independent, and as law-driven as they can be.
Thank you.
Mr. Sukup?
Thank you. Good morning.
Good morning.
As Chief Judge for your district, what's sort of your biggest challenge and how are you addressing it?
As chief judge personally, my biggest issue is balance, just because, on a given day I have my district judge duties and I have my chief judge duties. And most days the work goes like this, back and forth. I'll walk out of one hearing and into a question about a chief judge issue, etc. So on a personal level, it's just a matter of combining those two roles. From a district-wide professional judicial branch level, our biggest challenge right now is making sure that we're adequately staffing our rural courthouses, that we're keeping those courthouses active, and that we have sufficient clerk staff out there to make those courthouses run, and that we're figuring out a way to distribute our work processes across our entire district. My district is involved as a potential pilot district for a study concerning staffing in rural county courthouses and how we distribute the work across the entirety of our district, so that we're keeping the courthouse doors open, getting the work done in the busy urban areas as well. And so that's probably one of the larger issues that I'm dealing with on a day-to-day basis.
Thank you.
Thank you.
Ms. Sinclair?
No questions.
Ms. Diekma?
Thank you. Judge Lekar, you talked in your opening statement a little bit about the fact that when a Court of Appeals or Supreme Court decision comes down, you got to look at it both as a judge, but also as a chief judge, and how that may affect your district. I'd like to talk to you a little bit about that. Do you feel when you're issuing opinions, who is your audience? And do you think that audience would change as an appellate court judge?
When I'm issuing a decision as a district court judge, my audience is twofold. First and primarily, it's the litigants that were involved in the case. I write my decisions hopefully so that they understand my reasoning, that they understand the law that I'm applying to that reasoning, and that they understand the outcome. And that they can, whatever that outcome is, they can take it and apply it within their life or to their business or whatever aspect is before the court. I'm also, though, writing to some extent for an appellate court in the event that there's a review of that decision. And so I do try to write, I do try to make sure that I fully recite the facts that I'm relying upon, the law that I'm relying upon. When I'm in the courtroom, I try to make certain that we make a full record of things in the event that there is an appellate review so that it's available for the appellate court. So as a secondary audience, certainly I'm writing for the appellate courts potentially. As an appellate court writer, and actually Justice Wiggins and I have had this conversation about the differences between writing as an advocate, writing as a trial court judge, and writing as an appellate judge. And writing as an appellate judge, you do have to be mindful of the fact that you do have a larger audience, that you're not just writing for the litigants, although you continue to write to make certain that they understand the facts you're relying on, they understand the law you're relying on, and they understand the outcome. But you're also writing for maybe a trial court judge who's going to have to implement that decision in the event that there's a reversal, in the event that there is an affirmed but modified type ruling. Any remand that would require the trial court judge to take any steps needs to be clearly laid out. And so, and then of course you're writing for the public, and you're writing for the attorneys and the bar to be able to understand and use those rulings into the future.
Thank you.
Thank you.
Mr. Goodman?
Thank you, Your Honor. Judge Lekar, thank you very much for applying. I've asked earlier applicants this same question, but I'm interested in hearing from a variety of district court judges on this. We have 30 applicants for 6 spots. 12 of those applicants are district court or associate district court judges, 10 private practitioners, and 8 government lawyers. I've had people prevail on me and say the best people to serve on the Court of Appeals are those people who have been judges at the district court level, because they're in essence going to have to judge judges. And the best people to do that would be people who have sat at the district court level. That makes the list much smaller, obviously, and all we have to do is pick half of the 12 judges that have applied. And I'm not sure that's fair to the other applicants. I do agree, though, that district court experience is important, so I'd like you to help me, not just in your own individual application, but from your perspective as a chief judge. What should we look at as a commission in the district court applicants or the associate district court applicants, and at the lawyers, to pick the best 6 to fill the positions we're asked to fill?
With regard to any applicant that you're reviewing, I think that you need to be sensitive to the depth and breadth of their experience. I know that those are words that you guys hear over and over again. I have deep experience, I have broad experience. And certainly that's important. The variety of situations that they found themselves in, meaning, I kind of look at what we do as kind of a top to bottom and side to side thing. A top to bottom meaning everything from small claims and simple misdemeanors all the way up to felonies, and side to side meaning anything from a civil case or a juvenile case to, again, a felony murder case, or both pre-trial, post-trial procedure, plea colloquies, all those things that make up not just one aspect of a case as it works through the system, but the entirety of the aspect of a case as it works through the system. So whether they're coming at it as a judge with judicial experience or coming at it as an attorney, having had that wide array of experiences is also important. I think you're looking for people who have had leadership experience. It would be my assumption. While the Court of Appeals is the intermediate appellate court in the state, it certainly is also an opportunity for leadership within the judicial branch, and I think that skill set is also important. So I think no matter whether you're looking at someone who's been in private practice or whether someone who's been on the bench, and yes, I do think that there is a value to the skill set that a person develops on the bench, not just because you're judging judges, but also because, again, you're understanding what that judge went through when you're reviewing a case, but you're also sometimes instructing that judge on how to deal with a case when that case comes back. And I think it's important to note again that the two people who are being replaced did have trial court experience, and that would be a nice complement to add back onto the court to the existing members.
Well, we've run out of time, Judge Lekar.
Thank you very
Thank you.
much.
Thank you all for your
We
time.
thank you very much for coming, and we wish you the best of luck.
Thank you.